Testing 1 2 3. Testing 1 2 3. This is a test of the Seventh Circuit Court of Appeals. Testing 1 2 3.
Good morning. We'll call our first case for the morning, and Curtis Oates versus McHenry County. You may approach. Flaxman, how are you this morning?
I'm fine. Good morning, and may it please the court. Back in August of 2021, Mr. Oates had an unpleasant interaction with an animal control officer from McHenry County. That unpleasant interaction developed into a lawsuit that he originally filed pro se, and then he found counsel to take it over. The district judge granted summary judgment to the defendants, and we appealed. In our opening brief, we raised three arguments. First was that the defendants had waived qualified immunity. The second was that there was a Fourth Amendment protected right of privacy to the contents of your mailbox. And the third was that the curtilage issue, we alleged that the officers had the officer had crossed the curtilage to inspect the contents of a mailbox. The defendants responded, and after reading their response, we have given up the first two issues. We're not contending that they waived qualified immunity, and we're not contending that there's a privacy interest in the mailbox, even though I love that issue. I just think that it's not going to work today.
Why not? Why not?
Because there hasn't a case saying that the federal criminal statutes apply to the Fourth Amendment right of privacy, and the way that this court and the Supreme Court and all the circuit courts have construed qualified immunity is that we need that decision. Perhaps this case would have been one if we sought to, if the court decided to.
Don't think the cases in construing the statute make it clear that there is that right of privacy.
No, I mean, the cases construing the statute seem to be very dismissive of the right to privacy that the Supreme Court has recognized or discussed, and perhaps in dicta. And I think that we have a very tough row to hoe in showing that the law was clearly established. It should be, but we're not going to do that in this appeal, because the better issue, and the one that we're proceeding on, is that the officer crossed the curtilage to inspect the contents of the mailbox. And that district judge said that wasn't clearly established, even though there are two cases that we cited that seem to clearly establish it. In their answering brief, the defendants chose to ignore that issue. There's one sentence saying that the judge was right on his ruling about the curtilage. There's no development, there's no discussion, there are no cases cited, there's no analysis. Under this court's decisions, they waived that issue.
We usually don't go out of our way to find that issues have been waived in terms of defending a district court's opinion or decision.
We cited.
Could you focus in on your response to the district judge's analysis?
District judge did not do an analysis. He cited two cases and said, these cases don't apply.
And said the burden is on you.
And the district judge, if reading the district judge's opinion in the light most favorable to what he said, he was saying we need a Supreme Court or a Seventh Circuit case saying that when an animal control officer crosses the curtilage to look inside a mailbox, there's no qualified immunity. In Jardine, the Supreme Court set out what seemed to be a very general rule that you can't cross the curtilage to search. And they made that clear in the Collins versus Virginia, where they suppressed evidence because the officer had crossed the curtilage to inspect the motorcycle that was parked in the curtilage.
Looking at U.S. versus Dunn, what do we have in the record that demonstrates that the mailbox, Mr. Oates' mailbox, was within the curtilage?
That wasn't an issue that the defendants raised in the motion for summary judgment. So there's nothing in the record about that. There's the law that curtilage is protected and you can't cross it, but the factual question, I think perhaps the defendants wisely agreed, that was a question for the jury, is where the mailbox was. You have to cross the curtilage to get there. There's no discussion of that. We don't have to prove our case in opposing summary judgment on qualified immunity. We just have to if the facts are placed in question, we have to show a disputed question of fact. But I think Jardines and Collins versus Florida make it clear to any reasonable person who's enforcing the laws of a municipality or the federal government that you can't cross the curtilage to search for evidence. And there's no discussion at all of that, or no reasoning or argument. And there are cases that we cited where the appellee did not raise an argument and the court said, we're not going to consider it. I know this is troubling and I know it's regrettable. But
I'm not sure how it fits together since you've given up the mailbox question.
I've given up the searching the mailbox. Well, what if they searched a motorcycle that was parked on the curtilage? There's no right of privacy in the contents of a motorcycle like there is in a mailbox. But we've given it up because I don't think that we need to show a privacy interest in the contents of the mailbox to maintain an action for crossing the curtilage to search.
What are his damages?
That's a question for the jury.
Come on, Mr. Flaxman, what are we doing here?
Mr. Oates was very, very distressed about what happened. I didn't go out and find this case because there's a guy who wants to who I wanted to make new law and make a lot of money on. He was very distressed about the violation of his rights. He has a history for which his invasions of his rights are very important, and he wanted to enforce them. That's why I filed the pro se case. And even if this is a nominal damage case or a $19.99 case, it's a case that states a claim, and he's entitled to a trial, whether it's before a judge, if somebody says it's a $1 case, or to a jury, if we can persuade the district judge, that it's over $20 at issue. And I think we have to respect constitutional rights and enforce them, especially when Mr. Oates felt strongly enough about it to file this lawsuit.
So the thing I'm struggling with, to be blunt about it, is that the officer's free to walk up to the front door and knock, right?
That's correct.
I understand you're saying he's not free also to search, but if he's just stepping off the road to look in the mailbox and you're saying there is no privacy interest in that mailbox, I'm having a little trouble putting this all together. This is not comparable to, at least it doesn't seem to be comparable to having the drug sniffing dog at the door.
Your Honor is making a very interesting argument that's worthy of a response, but the defendants didn't make that argument, and the court.
I'm asking you.
You're asking me
how you avoid a qualified immunity defense that was raised and was accepted by the district court. Telling me that the defendants didn't do a good job of briefing is not going to convince me to reverse an otherwise correct decision of a district judge.
Well, it's not correct because the district judge said Jardines and Florida and Collins versus Virginia don't apply because they're not fact-specific enough. That's not the law on qualified immunity as this court.
I think I have your answer. Thank you.
Crossing the curtilage is an independent constitutional violation when there's a search, whether you're searching a locked container or whether you're searching just something which is not otherwise protected. And that's our claim. And I urge the court to follow the rule that we let parties make arguments, we don't make them for them. Thank you.
Thank you. Mr. Owens?
Your Honors, good morning, and may it please your honorable court. To set up the analysis, I could just briefly summarize how we got here and was commented upon by Justice Hamilton. Once the defendants waived the issue of whether or not we've raised the affirmative defense of qualified immunity, and once they essentially withdrew the issue about whether there was an expectation to privacy of the contents of the mailbox, the analysis essentially becomes, respectfully, more simple. Critically, in the world of Fourth Amendment searches and seizures, or whether or not there's an illegal or unreasonable search and seizure, the only search and seizure complained of in the history of this case is the mailbox, which has been withdrawn from the court's consideration. Put another way, the appellant has not complained of a search and seizure in this case that he hasn't withdrawn. Today, he maintains that defendant Enos crossed into the plaintiff's curtilage, violated plaintiff's Fourth Amendment rights, and fails to identify a search or a seizure that he hasn't withdrawn. His claim is that we have not adequately responded to the issue and that we waived the issue. To my way of thinking, in the brief, we have made clear we don't think he discharged the Archer burden once we've raised the issue of qualified immunity. In our brief, we cited the Archer. I know the court is well aware of the analysis, but effectively it comes down to now, given where the appellant has chosen to take the court, the question is, are the facts established to conclude the defendant violated a clearly defined right and that the unlawful conduct was clearly established at the time of the alleged violation? Our position in our brief, and our position here today, is that the appellant has failed that burden. To be clear, what
So what I'm hearing is that without the mailbox, with that taken off the table, there's been no search. There's been no warrantless search.
We're right, and I'd like to address that a little bit further with Jardines and Collins as well. Exactly, Your Honor. Each time in the plaintiff's opening brief that plaintiff complains about the curtilage, and three separate portions of the curtilage argument, he couples it with to get to the mailbox in order to search the mailbox. It's access to the mailbox, I think, are the three exact quotes in the opening brief. To be clear, there's never once in the history of this case been a complaint about an illegal seizure. It's always been, in his writing and here today, getting to essentially the curtilage to search the mailbox. Effectively, what he's saying is the violation is the location of defendant Enos's feet. His feet essentially is the entire violation because he's waived the issue about whether or not the conduct at the mailbox violates a clearly established right or right and expectation of privacy. And this is different than Jardines. I know the court knows the facts of Jardines. The curtilage in that case was the front porch attached to a house. That's far different than a mailbox somewhere that we don't know off the real property near the street. In that case, we know the officers entered the real property of the porch, used a canine to conduct a canine sniff search, obtained evidence by clear investigatory conduct, and used the results of that sniff search, that Fourth Amendment search, to obtain a search warrant. The sniff search itself was critical in gathering evidence in the defendant's criminal prosecution in that case. And then, most importantly, in Jardines, the plaintiff in that case, the criminal defendant in the trial court and the appellant in the appellate court did not waive the expectation of privacy that he had to what was at the front porch during the dog sniff search. In Collins, the curtilage it's more than a motorcycle. The court goes out of its way twice to say the motorcycle was parked, quote, on top of the driveway. And the critically point missed by my opponent, respectfully, the motorcycle was covered by a tarp. In that case, the officer entered into the real property, went to the top of the driveway, and then removed the tarp to obtain a license plate, and that evidence was directly used in the criminal prosecution that became the basis of his appeal. Here, I respectfully submit to your honors, this is totally different. Plaintiff's evidence that he put in the record, and this is the only evidence before your honors, is that there was a mailbox. He claims in his reply brief, in his opening brief, that the mailbox was, quote, not on the curb, unquote. He goes on to say that the mailbox was, quote, not easily accessible from the street. I respectfully submit that there's nothing else in the record that makes this, I guess, last case made by him in his reply. It's important to point out, I respectfully submit that there's zero evidence of the distance of the mailbox to the street. There's zero evidence of the distance within the real property that the mailbox was supposedly within. And there's zero evidence that of the distance between the house and the mailbox. And then critically, there's zero evidence that's used in any prosecution of the case. And unlike Collins, and unlike Jardines, this appellant waived the expectation of privacy that forms the basis of his appeal.
Mr. Owens, can I ask you just, do you think the police ought to need to get a warrant if they want to take the inventory of my mailbox every day, what's incoming and what's outgoing? They want to see if I'm reading Russian propaganda or leftist magazines, or who I'm corresponding with?
In answer to the question, Your Honor, may I accept that this is a hypothetical, unsupported?
Of course it's a hypothetical.
Okay. In the specific facts of that case, that is a more likely scenario where there should be a search warrant. And to be clear, we've never admitted that this happened on behalf of Defendant Enos. We've denied this in the summary judgment.
Thank you.
In our brief and before Your Honors today, it's the government's position, it's McHenry County's position that the plaintiff waived the issue about whether or not the mailbox was protected by any expectation of privacy, and in doing so, failed to establish any clearly defined right that has been violated, and has clearly failed to identify unlawful misconduct on behalf of Defendant Enos, and the district court's ruling was correct. I have nothing further for Your Honors. Your Honors, thank you.
Thank you. Rebuttal?
The argument about zero evidence highlights the fact that that wasn't an issue in their summary judgment motion, which is reproduced in the short appendix at 20 to 22. And I have a hypothetical to leave the court with. What if the police were investigating a homicide and crossed into the curtilage looking for bullets and found bullets because they had crossed through the curtilage? That would be an unlawful search. It would be suppressed. This is the same thing that happened here, and we should proceed to trial. Thank you.
Thank you. The court will take the case under advisement. We call our next case for the morning, Mary Arnold versus UAL. Mr. Horowitz, give us just a moment. All right, you may proceed.
Good morning, Your Honors. May it please the Court. I'm Jeremy Horowitz with the amicus EEOC in this case. And I'd like to address two primary points today, if I could. First, that a reasonable jury could find that the actions United took against Ms. Arnold satisfied Muldrow's new test for an adverse employment action as part of a disparate treatment claim. And second, that a reasonable jury could find that the PIP satisfied Burlington Northern's likely to dissuade a reasonable worker standard for retaliation claims. So turning first to the disparate treatment claim, the district court erred when it applied this court's pre-Muldrow standard to find that United did not subject Ms. Arnold to a sufficiently adverse employment action. But Muldrow clarified that this material adversity requirement is not the law, and instead stated that a plaintiff needs only to show that there was some harm to an identifiable term or condition of employment. A reasonable jury here could find both that losing the Core 4 project and being placed on a PIP were both sufficient to meet Muldrow's some harm standard, or some harm threshold. With respect to the Core 4 project, it was an expression of United's foundational company values. It was high priority for United. Ms. Arnold testified that it was high profile, high exposure for her, and that she found it really rewarding. She also testified that after she was taken off the project and given something else, that was not nearly as rewarding a job assignment. And so a reasonable jury could find that losing that project met Muldrow's standard for some harm to the terms or conditions of employment. Turning next to the PIP, she testified that it created substantial additional work for her. She also testified that it created a pervasive layer of constant scrutiny and threats, and these threats were borne out by the terms of the PIP itself, which said that even after its successful completion, somebody who had been on that PIP would still be subjected to an accelerated termination process in the future. So a reasonable jury hearing that could certainly find that that was enough to constitute some harm in the terms or conditions of her employment. Then turning to the retaliation claim.
Would a negative review amount to satisfy the Muldrow standard, do you think?
Potentially it could, Your Honor, if the negative review was, that sort of goes to the causal element. If the negative review was because of an employee's protected characteristic.
Well, those are two separate questions.
Well, yeah, so I'm sorry, Your Honor.
Assume improper motivation. Is the negative review on its own an adverse action under Muldrow? It would not be under our case law, as I understand it, going back several decades.
Mm-hmm. Yes, Your Honor. I believe in Your Honor's hypothetical, a reasonable jury could find that did constitute some harm, the negative performance review, if it was given. And I realize I'm shading into the causation element, and you wanted to stick to just the some harm aspect. But in this case,
that's what I understand your amicus brief wanted to do.
Yes,
too.
exactly.
So
Precisely.
I'm trying to stay within your limits.
I appreciate that, Your Honor. I appreciate
Okay.
that. Yes. So yes, in that case, I believe a negative performance review could, in fact, be sufficient to create some harm in the terms or conditions of the employment. If I could turn to the retaliation claim, a reasonable jury could find that the PIP on which United placed Ms. Arnold after it finished investigating her complaint of age discrimination was sufficiently adverse to meet the Burlington Northern retaliation standard. That PIP qualitatively changed the conditions, or a reasonable jury certainly could find that PIP changed the qualitative conditions of the plaintiff's work, which this court held in Louth was enough to meet the material adversity standard for a retaliation claim. Again, as I described, there's the additional scrutiny, the threats of termination, the additional workload, and the threat of termination that extended well beyond its completion. And a reasonable jury could find, when presented with that, that such a PIP could well be sufficient to dissuade a reasonable worker from coming forward with a complaint of discrimination, which is the test under Burlington Northern. I see my time is almost up, so if Your Honors have no additional questions.
Thank you.
Thank you.
Good morning.
May it please the court, my name is Kana Turley and I am a third-year law student arguing under the supervision of Professor Danielle Hamilton. We also represent the plaintiff appellant, Ms. Marianne Arnold, who is here in the courtroom gallery. In addition to my co-counsel's argument about the applicability of Muldrow to Ms. Arnold's case, we ask this court to reverse the district court's grant of summary judgment in favor of United and find that Ms. Arnold has raised genuine issues of material fact as to her retaliation, hostile work environment, and constructive discharge claims. Starting first with her claim of retaliation, the record shows that in October 2019, at around the same time that Ms. Arnold was making repeated internal complaints to Human Resources and to United's Deputy Counsel, there were documented discussions within United's upper management to push Ms. Arnold out of the company in response to these internal complaints. As part of these documented...
What was the nature of the internal complaints that you're referencing, Ms. Turley?
Your Honor, Ms. Arnold made complaints to HR and to United's Deputy Counsel about her seating arrangement near her former supervisor, whom she had accused of sexual harassment twice. And she also complained about her removal from the Core 4 project and its being reassigned to a younger, lower-level employee.
So we had a little bit of some sexual harassment complaints and age complaints. I think it'd be easier if we would separate out what went to which claim. And so for purposes of the retaliation, did she allege below that she was being retaliated because of her sexual harassment complaints?
She did, Your Honor. Although her prior counsel did not explicitly write these sex-based internal complaints into the claims portion of her complaint, the facts section of her complaint, as well as her response to United's motion for summary judgment, are replete with these allegations of sex-based protected activities that do serve as a basis, in addition to her age-based protected activities, of her retaliation and hostile work environment claims.
So I've had an opportunity to review the response, and so the representation is that she was also raising sexual harassment complaints in regards to the retaliation. And so when we're looking at the amended complaint, I noticed that the sexual harassment claim had been removed from that because it was in the original, but it was not in the amended.
Your Honor, it's unclear as to why prior counsel removed the explicit mention of that complaint. However, in the facts section of her complaint, she does still discuss that she engaged in protected activity at the time that she was making these internal complaints about her seating arrangement. Regarding the exact mentions of that in the record itself, or rather in the complaint, for example, on paragraphs 16 through 17, Arnold alleges that she did report her former supervisor for sexual harassment. And then additionally, in paragraph 23, she alleges that she was harassed based on age and in retaliation for participating in a protected activity. And it's a reasonable inference in Ms. Arnold's favor that that phrase, "and in retaliation for participating in a protected activity," does refer to her sexual harassment complaints against her former supervisor, as well as the continued complaints regarding being forced to sit near him. And this also goes to her hostile work environment claim, and I realize I'm sort of blending the two together, but at least in as far as her seating arrangement was concerned, the fact that she was forced to sit near her former supervisor, and the fact that when she escalated this complaint, she was told to consider her...
And where was it raised in the response?
In the response to United's motion for summary judgment, page 9 of the response indicates that Ms. Arnold engaged in several instances of protected activity, including reporting her former supervisor for sexual harassment and making internal complaints about being assigned to sit near her former supervisor. And again, part of her hostile work environment claim is that this created a very objectively and subjectively offensive and abusive work environment, as during that time she reported that she was seeking treatment from doctors for the physical and emotional stress from this very distressing situation, and that she was regularly crying at work. And again, when she escalated this, United initially told her that she should just consider her long-term plans at the company. But circling back a little bit to retaliation, there is a strong causal relationship between these internal complaints that she made and then her placement on a PIP and the issuance of a negative review, which was the first negative review she had received in her 25-year career at United. This court has acknowledged that things like suspicious timing, as well as vague or ambiguous statements from an employer, can be circumstantial evidence of causation, and Ms. Arnold has provided evidence of both. Regarding vague or ambiguous statements, there were documented discussions within United's upper management about offering her a retirement package at the time that she was making these internal complaints. And they debated.
But we have to slow down because we're merging the different complaints, and that's is what the district judge emphasized repeatedly. The 2018-2019 internal complaint is about sexual harassment. And so the retaliation in 2017, when she makes the age complaints, how are we tying that to the PIP?
Your Honor, we don't dispute the district court's finding regarding her 2017 complaint. However, as part of the internal complaints that she was making in October 2019, she did identify herself as an individual over the age of 40, thus falling within the protected class of the ADEA. And she did discuss about how the Core 4 project was taken away from her and reassigned to a younger employee. And this was, again, a complaint that was raised to United's deputy counsel, thus falling within a kind of age-based protected complaint that can certainly serve as the basis for both her retaliation and hostile work environment claims under that statute. And again, there's evidence of ambiguous statements made by United
There's no representation, though, that the hostile work environment in the complaint was tied to sexual harassment.
There is, Your Honor, and that's because the hostile work environment, Ms. Arnold alleges, was in response to her making these protected complaints and her status as someone who had engaged in protected activity related to both sex and age.
Is the ambiguous statement you're referring to the one by Michelson?
Your Honor, the ambiguous statements specifically are in document 47-13. These are documented discussions among United's upper management in which they, after debating whether to offer her a retirement package, ultimately decide to focus on performance. And then just a few months later, Ms. Arnold received the first negative review of her 25 years in United and was placed on an onerous PIP that is distinguishable from other PIPs examined by this circuit, in that it not only overloaded her with often very menial and time-consuming tasks, but also subjected her to a level of scrutiny and blame.
Counsel, I'm looking for some indication of age-based animus.
Your Honor, at least as far as the retaliation claim goes, and I see my time is about to.
I've got a couple other questions. Please answer, if you would.
At least as far as the age-based retaliation argument goes, the fact that Ms. Arnold did make an internal complaint about age discrimination, and then just several months later received the first negative review of her career, does indicate that there was some sort of causal relationship between that age-based complaint.
Sorry, I'm going back to the merits of the age claim. Is there any indication of age-based animus here?
If discussing the merits of the age discrimination argument, there is, looking at the circumstantial evidence that Ms. Arnold has provided, specifically that she suffered an adverse employment action, as my co-counsel mentioned.
I'm asking for some explicit, if you want to just rely purely on an indirect McDonnell-Douglas proof, that's fine. But I had understood you to be arguing in your brief that you thought you had some indication of age-based animus on the Michelson comment.
Yes, Your Honor. So that statement.
And my question about Michelson is whether there's any indication that she had anything further to do with decisions about Ms. Arnold's employment.
Your Honor, the record shows that Michelson was included on all of the discussions regarding potentially offering Ms. Arnold a retirement package.
She was copied on emails.
Yes, Your Honor.
Anything else?
No, Your Honor.
Okay, thanks. A couple of quick questions. Am I correct that all the sex-based claims arise only under state law here?
Yes, Your Honor.
Okay, also, in your appendix, I was looking for the judgment. I didn't see it.
If I may clarify, Your Honor, are you just discussing the district court's opinion?
The Rule 58 judgment, not the opinion, the Rule 58 judgment that says the case is over.
Your Honor, I can address that further on rebuttal. I would have to double check to see if that was included in the appendix.
It's not in mine, so thank you. It's a required part. Thank you.
Thank you, Your Honors.
All right, thank you. Mr. King?
Good morning, Your Honors, and may it please the Court. This is a case like so many before it where the plaintiff subjectively believed that her performance was far greater than it was in the eyes of her supervisors and managers. And that would be multiple supervisors and managers, both before the reorganization and after the reorganization of the department. Under appellant's version of events, she had no performance issues at all until after the reorganization and after she starts sending emails in October of 2019. But the undisputed facts tell a far different story. As far back as her year-end evaluation in 2018, and then again in her mid-year evaluation in 2019, the same themes and the same comments on her performance deficiencies were included way back then. In fact, they were so significant that prior to the reorganization, her supervisor at the time, Ms. Millichap, went to HR and spoke with Ms. Tirado about her concerns about Ms. Arnold's performance deficiencies. All of this predates even the reorganization, and it predates these October emails that were discussed previously. Not only that, with respect to the performance issues that were documented in the PIP itself, Ms. Arnold did not even claim that those performance issues were not legitimate. She was asked at her deposition if those were accurate and legitimate critiques of her performance, and her answer was, "I can't recall." So Ms. Arnold doesn't even allege that. Jumping to the sex-based claims, as Judge Pryor pointed out, that was expressly removed in the amended complaint. And, you know, counsel is trying to suggest that, well, there's some paragraphs where you can infer something like that. This isn't an esoteric issue. This is like your main claims. Are you alleging gender-based discrimination, gender-based hostile environment, or gender-based retaliation? And for that to be completely absent in the complaint, and more importantly, rather the amended complaint, but more importantly, to not raise those issues in the district court in response to our motion for summary judgment. So, you know, there are suggestions in the briefs that the counsel below should have, you know, raised certain things and didn't. You know, I can only tell you that this was a long, hard-fought piece of litigation, and if they believed they had a gender-based complaint, counsel would have been jumping up and down in response to our motion for summary judgment, which never happened.
In her response to the motion for summary judgment, counsel did direct the court to the retaliation, the unlawful retaliation. And on page 9 of the response said one of the protected activities that we want the court to consider is the 2018 complaints of Stephen Jones for sexual harassment.
Yes, and our response and our point was that it was clear to us that they were only alleging an age-based retaliation claim. So our response was, you cannot use these prior gender-based Stephen Jones complaints as protected activity that would support the age claim. Now, again, you know, without some clear indication that they're alleging a gender-based claim, you know, that was our understanding that they were not. And so our argument was that you can't use these gender-based things for your age-based discrimination claims. Turning to the discrimination claims with respect to Muldrow in particular, even setting that aside for the moment, because I don't think this court needs to reach that question unless it so desires, because the district court correctly entered summary judgment for several other independent reasons, including that there was no showing of any substantially younger employee who was similarly situated and treated more favorably. Her coworker, JP, was not substantially younger, and obviously that creates a presumption that age was not a factor. Appellant has certainly not overcome that presumption with any evidence, and frankly the most that they can muster is this one comment from Michelson inquiring about her seniority date in the same conversation of telling her that Michelson, had just recently joined the company. So there are cases before this court where the court has been clear that even overtly asking employees about their retirement plans is not evidence of age discrimination, so we certainly don't have any here.
What aspects of Arnold's job responsibilities changed after the reorganization?
Not much. I mean, she was still responsible for internal corporate communications. They may have been not for the same areas, but it was essentially the same job. The core four, which she acknowledges in the complaint, was 85% complete at the time of the reorganization. That was moved under a separate group of employees. And again, those employees were not similarly situated because they were part of a newly created team to focus on projects like Core 4, but not only Core 4, other projects that Ms. Arnold had nothing to do with. I hear the suggestions to the contrary, but there's really no evidence in the record that her job duties were materially changed as a result of the reorganization. And, with respect to Muldrow, again, we recognize that this court has stated that Muldrow may apply outside of the context of a job transfer, but it's really appellant who has been arguing that this is a job transfer case and trying to neatly fit this case under Muldrow and the other job transfer cases. In our view, this is not a job transfer case. A job transfer is when someone is singled out for some reason and transferred to a less desirable position. I mean, what we have here is a complete reorganization of an entire department that impacted not only Ms. Arnold, but tons and tons of other employees and other employees on her team. So this is really not a job transfer case. And why that's relevant is that I think the job transfer cases, by their very nature, are more adverse. Again, that's somebody being singled out and moved into a less desirable situation. That's inherently more of an adverse employment action.
Mr. King, I
Yep.
take it you'd agree that Muldrow's logic does extend to the Age Discrimination Act.
It does, yes.
Okay. Can I also ask you to focus on one of these conversations, I think it was in the fall of 2019, where the plaintiff was complaining about her being seated close to Mr. Jones after this reorganization. And it was a Patterson responded in that discussion that we need to focus on her performance. Help me understand why that was germane.
Well, I think the question at the time was, they were already focused on her performance, number one. That's the reason that she was put on the PIP and that they were having these performance management discussions.
But in response to a complaint where somebody who has previously made a complaint of sex harassment, ordinarily most employers will try to work out some kind of separation in those cases.
Right.
She's put back within a few feet of him, as I understand the evidence here. And when she raises a question about that, people say, well, let's focus on her performance.
Yeah, I think it was Ms. Tirado who said, and she was just questioning, and I think reasonably and rightfully questioning, what is the message does that send if we're going to just give a separation agreement to a poor performer? The performance issues had gone all the way back to 2018. So she believed that they should continue in their process of focusing on her performance and not reward, if you will, someone with a separation agreement who was a poor performer. So that was the basis of that response.
I guess I'm having trouble. Would that be thought of as a reward or sort of? I thought that was kind of a basic step when you've got he said, she said kinds of conflicts and accusations of sexual harassment. Yeah. Particularly if an employer doesn't want to run it to the ground and figure out who's telling the truth and who's not.
Yeah, there had already been an investigation years prior of the entire sexual harassment complaint, and it was found to be unfounded. So this was not raised near the end of her employment. She brings it up again near the end of her employment. But there was a full investigation previously on that. And, you know, action was taken. She complained about where she was going to have to sit, and United made a change and allowed her to sit even further away. And she gave some acknowledgement that that was, you know, acceptable to her.
But wasn't that made, so she meets with general counsel, and then the next day we have this email traffic saying, now we're going to focus on her performance?
Well, I don't think that was the context of now we're going to focus on her performance. I think the response was we're going to continue to focus on her performance.
It says we will focus on performance.
We will.
The day after she receives basically a workaround, HR. HR has told her, nope, we're not moving you, in essence, and then she meets with general counsel. General counsel agrees with Ms. Arnold. The next day, there's email traffic, including HR representatives and her supervisors. We will focus on performance.
Right. And I think it's clear in the context of those communications that there were two things at issue. Are we going to go a separation agreement route, or are we going to continue to focus on her performance? And it was Ms. Tirado who, as an HR person, sort of sounded the note of you know, why and what message would that send that if we were going to issue a separation package to a poor performing employee. They dealt with the harassment related issue in terms of giving her a better seating arrangement. But those were the choices of whether, and why I say rewarding, I mean, the separation package would presumably include some compensation.
Sure, you're talking about separation, not just seating arrangements, but rather leaving the company with some money.
Yes.
Okay, sorry.
Yes,
I misunderstood.
those were the
you
two
earlier.
things. It's do we give her a package, pay her to leave the company, or do we continue to focus on performance? So those were the two things under consideration. I don't think it's unreasonable for an HR person who's been dealing with issues for over a year about a particular employee to question why would we give her a separation package. So that's the context of those discussions. I had a lot more I was going to go through, but I don't think I need to go through all of it. Again, on the retaliation, I think all there is an age-based retaliation claim, and you know, there's no evidence in this record that anyone ever said anything about Ms. Arnold's age. No basis for believing there's any age-related animus, or for that matter, gender-related animus. There's simply no evidence of that in the record. So there's certainly no causal connection between anything that she complains about and any protected activity in that regard. And we disagree that the things that she alleges being put on a PIP and having a portion of her one assignment transferred to somebody else, we don't think that meets the materially adverse standard for retaliation, which frankly is now more exacting than the Muldrow standard for discrimination. So I think
you think the Supreme Court wants us to draw two different lines now between retaliation and discrimination cases, having now flipped the relative burden?
I think so. I think there were always two different lines in terms of one was adverse employment action, and then, which was a focus on did they lose any money, did they get demoted, and then the material adverse standard could be broader, could be things, I think even the courts have talked about, there could be things that happen even outside the workplace that, could fall under this kind of materially adverse standard. So there's no question that the court narrowed the discrimination standard under Muldrow.
They relaxed it.
Yeah, relaxed it, yeah. But to your point, Judge, you asked the question, I think, that if there was just a poor performance evaluation, would that be an adverse employment action? And I hope that answer is no. Otherwise, every performance evaluation, every performance improvement plan is going to lead to a cause of action. It's going to be before this court and you'll be asked to sit as a super personnel department, which you've said countless times is not your responsibility. With that, if there are no more questions.
Thank you. Mr. Allen?
Your Honors, may it please the Court, my name is Jacob Allen, representing Plaintiff Appellant Ms. Mary Ann Arnold. First and foremost, the Rule 58 judgment, Judge Hamilton, to your point, was inadvertently omitted from our appendix. We would like to seek leave to supplement the appendix.
We know where to find it. I'm just saying, and it's not a big problem here, but there's a reason that it's in the rule. We don't need to worry about amending documents at this point, in my view.
Yes, Your Honor. And Judge Hamilton, to another point you made earlier, you asked whether any negative review would satisfy the adverse employment action standard set forth in Muldrow. And to us, we agree with some of the comments stated at the end by United there that not all negative reviews would constitute an adverse employment action under Muldrow. However, even predating Muldrow, there's case law in this court, such as Louth v. Covance, that states that a performance improvement plan or a negative evaluation with more can constitute an
What's
adverse
the more
employment
here?
action. The evidence of more, the conditions that make this PIP particularly onerous are that Ms. Arnold's quantitative amount of work was increased. She was assigned additional assignments, particularly menial assignments. She was asked to identify trainings, to sit in on lengthy regular meetings, to create agendas, things that were far below the expected assignments for someone that had been with the company for 25 years and the assignments she had typically been doing.
Is there any evidence in the record of what would have been the expected assignments for someone in her situation?
Yes, Your Honor. It really speaks to the change in assignments and the change in the nature of her work following the placement on the PIP. She was simply not interacting with business partners to the same degree. She was, again, being asked to do very low-level menial work, such as create agendas. At the same time as these very quantitative changes, she was experiencing disparagement publicly in front of business partners, in front of coworkers. These conditions are not analogous to other cases from this court that
What
are
kind of
simply negative
disparagement?
evaluations. Things of the nature where business partners would praise Ms. Arnold's work and say that they had no comments and they were satisfied with it, and a supervisor such as Ms. Shaw would come in after the fact on the same email thread and very publicly criticize the work that was already receiving praise.
That happens in my chambers,
Yes.
right? People will evaluate one another's writings, and some people say looks good to me, and others say not so much. Is that part of a hostile work environment?
Well, no, Your Honor, not necessarily, but it is the amalgamation of these conditions. So you have repeated instances where this is taking place, and the tone and the content is particularly disparaging towards Ms. Arnold. And within the conditions already being imposed through the PIP, this in and of itself was hindering her professional reputation, harming her business relationships within the company. And then on top of that, even when she's producing quality work in the eyes of her business partners, she's being repeatedly admonished.
This reorganization, this PIP came after the reorganization, am I right?
Yes, Your Honor. So
About how long after the reorganization?
the PIP came roughly 4 months after the reorganization. And she suffered adverse employment actions in both instances because the transfer, and speaking to a point asked earlier, United raised that this was not necessarily a transfer, and the record says in 4710 you can see that Ms. Arnold was transferred from a group of corporate writers comprising roughly 20 or so individuals to a group of 3 and then 2 writers. At the same time, her workload is being increased, and the COVID pandemic has led United to implement a policy where they're cutting everyone's hours by 20%. So she has less hours in the day to complete her work, yet she's being assigned additional work, more menial work, and she's being criticized while completing that work, even when the work product is deemed positive by her business partner.
When was it she resigned?
She resigned in May 2020, Your Honor.
So a few weeks after the COVID pandemic spread.
Yes, I mean, within
you.
the same few month period, yes, Your Honor.
Thank you.
Am I out of time here?
Yes, you are,
Okay,
Counsel.
thank you so much. For these foregoing reasons, I'd ask that you reverse and remand. Thank you, Your
Thank you.
Honors.
And thank you, counsel, for both sides. I also want to especially extend our thanks to Northwestern and Professor Hamilton, Ms. Turley, Mr. Allen, for representing Ms. Arnold in this matter. We appreciate your service to the court. Thank you. Call our next case for the morning. Sortier Laborov versus Immigration Customs Enforcement. Give us just a moment. This laser, can it just, it's clearing out behind you.
I'm sorry, Your Honor.
It's clearing out. Just give us 1 second. All right, you may proceed.
Good morning, Your Honors. May it please the court. My name is Nicolette Glazer. I represent the appellant, plaintiff in this matter, Mr. Libarov.
It's a little hard for me to hear you. Can you lean? Yeah.
Yes,
sorry.
Your
The
Honor. I
microphone
apologize.
is not amplifying, it's only recording, so
Thank you, Your Honors. Is it that better?
a little better, yes.
Congress enacted the Freedom of Information Act in 1966 against a very vocal and strenuous opposition from the executive and its agencies. Since then, Congress has amended the act multiple times, including in 2007 and 2016 as it relates to this matter, to both repeal restrictive court opinions as well to emphasize that the purpose and goal of FOIA was to make it easy for requesters to obtain the information that they were seeking. And yet, the district court, at the urging of the defendant, accepted the view of the act, which from the standpoint of a FOIA requester is basically the prototypical heads I lose, tail you win. I'd like to point to the facts of this case that is somewhat different from the usual FOIA cases that ended up in the district court, which oftenly are related to after the administrative appeal is exhausted, is a question about the search, the proper withholding, and matters that are basically to the whether the agency did what they're supposed to do. In this case,
So what remedy, if we accept that there was a violation, right, of the timing requirement, the 20 days, what remedy at that point was Mr. Libarov entitled to?
well, from the standpoint of the requester, I think the remedy is a declaration that there is a FOIA violation. And that FOIA, if there is such a finding, then first it sends a very strong message to an agency that they could be held in a declaratory judgment that they violate the act. If you have a multiple of those, it goes to a pattern of practice, which we allege in this complaint in the third count. But more to it, it also makes the FOIA actually a statute, because if there is a judgment in favor of Ms. Libarov or anybody, he will be able to establish much easily that he's a prevailing party and obtain.
But doesn't he receive that by being able to come into federal court?
Well, Your Honor,
As far as this notion that you don't have to exhaust the administrative remedies, you have now access to the court because Immigration Customs and Enforcement have violated the timing. I guess I'm going back to, what is the remedy that your client would receive based on the timing violation?
Your Honor, if I may, the issue of exhaustion is a sort of a predicate to allow the entity to go to court, or the person to go to court, sort of reaffirms that there is a private cause of action. The question is, once you're in court, what is the remedy that goes once you state, if you state a cause of action for violation? And it was, as with any cause of action, if there is a violation, there is a remedy. And the remedy that was put in the act is an injunctive relief and declaratory relief. And here,
You said an injunction?
injunction and a declaratory relief. In here, if the court has accepted our reasoning that once you violate the act, then the court can say you have to produce these records within a time frame, not having 2 years in order to dribble down your response without obtaining an open America stay. In addition to that, since here we requested the declaratory relief, Mr. Ribarov can obtain a declaratory judgment that the act was violated and seek attorney fees. Here, under the precedent of this court and the District of Columbia, it will be a de minimis win, if there is any win, because there is no production, or at least there's some production pursuant to a court order, but it will not be Mr. Ribarov is not a prevailing party. We didn't seek attorney fees because under the precedent he cannot obtain it. What the ticket to court means is the requester will have to hire an attorney, spend 2 years in district court only to wait for the agency to come at their timeline, produce an interim response, and then obtain a judgment in their favor. Once they obtain a judgment in their favor, presumably they're entitled to their cost. So not only Mr. Ribarov not obtained what he was seeking, the court found that he's not entitled to more, but he spent 2 years litigating and could be paying the government cost, may not be big cost, but still cost for daring to go to court. That's what the ticket to court approach of the district court means, set to its bottom. Whereas the act was specific.
So I want to make sure I understand your argument, Ms. Glazer, are you representing that because there was a violation of the timing requirement that the government agency has accepted, that the remedy, once coming to court, is requiring the agency under FOIA to pay attorney's fees?
No, the remedy is to find that there is a violation and then put in order on the agency to do what the court finds it was not being done. Respond, issue a final determination, and then if there is a final determination that is not completely satisfactory to the requester, then that requester will be able to appeal within the agency. So the remedy is to come in and say, you have X amount of time to produce a final determination and spell and put everything that the act required to put in that final determination. Now, it is the agency to do that, including to put in it, here's your final determination, the court ordered it, you have the right to do this, that, and then perhaps appeal within the agency. What happens with these FOIA cases when they end up in court is that none of these additional rights or safeguard or safe rail that were put by Congress in the act to allow a requester a quick and expeditious sort of conversation with the agency to obtain the relief is completely evaporated, because once a person gets in court, the only question is how long it will take for the agency to say, we conducted the search, here's the document, and ultimately get a judgment in their favor. Because the way the courts are seeing it is, even if the requester wins something and it says we need to do another search, the next step is the agency coming up with another motion for summary judgment until there is nothing else left, and then the judgment is in their favor. And so the argument that we are making is that could not have been the intent of Congress, providing a private remedy and a private cause of action which allows the requester to go to court and to obtain a de novo review and prospective injunctive relief. It means one thing, and that is, once you go to court, the court has to look, did the agency did something to violate the act? If it did so, it should issue a judgment and order the agency to do what they have not done, including issue a final determination, which was central to the amendments of Congress, by adding more layers of what needs to be done with that final determination, which consummate the agency action. And again, it's the agency and their expertise that is required in order to decide which component to search, who to search, how to search. That's something that is reserved for the agency. And the agency, once it completes that task, it has to provide to the requester and the court the final determination so that there could be an expeditious and central determination as to is there anything that the agency didn't do right.
Ms. Glazer, could I ask you, is there anything about the agency's search carried out in this case that you are challenging at this point?
No, Your Honor, we did not.
Okay, I guess I'm, at the risk of repeating my colleague's question, I'm trying to understand what further relief Mr. Lieberoff wants at this point.
Well, with respect to the document that was produced, we are seeking the court to find that exemption 7A was not properly applied.
Right, okay, I understand that. Anything else?
We asked the court to issue, or direct the court to issue a declaratory judgment that the act was violated and the agency should issue a final determination. All they issued is an interim determination that says
But your brief says that the agency has already issued a determination.
They issue an interim determination.
That's not what your brief says. Your brief says they entered a determination after we filed for summary judgment.
That is correct.
So they have issued a determination.
That's correct. In response to the motion for summary judgment, they issue an interim determination, not a final determination.
So now you're representing before the court that the determination was interim.
That is correct, and that is actually part of the motion for summary judgment, and the government does not contest that it's an interim decision. In fact, it says once.
I'm sorry, let's go back. So the relief that you're wanting is a declaratory judgment. Go ahead. I'm sorry, I interrupted.
A declaratory judgment and an injunction, prospective injunction, that the agency issue a final determination. That because in the interim they said, once we complete the investigation and the investigation is no longer open, we may assert further exemption, including 7C, 7D, and exemption 6. So what they admitted in the determination that was in response to our motion for summary judgment, that what they've said, this is the one document and we're going to withhold it in full, is not the end of their final action, because they claim that it's an open investigation. By their own terminology and representation, once this investigation is no longer open and exemption 7A, which they asserted does not apply any longer, then they say we'll come in and decide what we're going to do at that time, and there may be other documents. So what we raise in our brief is that there is nothing in the act and nothing in the response that suggests that an agency can obtain a judgment in their favor for an interim step, which is an interim decision, saying, so far this is what we have, we're going to get a judgment, and then maybe we'll respond to you later. There is nothing that I have found that sanctioned that sort of an intermediary response and obtain a judgment. We see those interim responses all the time in FOIA cases, but the search continues, the production continues. It's just let's say the 150 pages that we have processed pursuant to a court order that we're producing to the requester. But once they complete all the production and all the exemption, they will normally come in and say, here's our final decision. There is nothing else to produce. All the exemptions have been applied. This is the end, the consummation of our duties under the act. And then the legal issue as to is there anything left for the district court to remedy with a prospective injunction comes into place. We didn't get to that point because they came in with an interim response. If I very quickly can touch on the 7A exemption, which is the count 2 that was asserted in the complaint. Again, the main issue is that we have an interim response, but beyond that, we respectfully ask the court to perhaps, considering the fact of this case, at least explain further the two-step approach that this court applies to summary judgment in FOIA cases. And the level that kind of drops down from the regular Rule 56 burden is with respect to the exemption, that clear error portion. And we respectfully ask the court to consider that since it is the burden of the defendant at all time to prove and establish that they have satisfied the requirement for a 7A or any other exemption. When, as in here, we moved for a summary judgment under Celotex, pointing that they could not come up with enough proof. Because they bear the burden of proof at trial, then it is their burden to come with a...
What do we do with Hinson, though? Our Hinson case, where we say affidavit, sworn affidavit, Vaughn index, in-camera review by the district court. There's enough there for the district court to make a decision as to whether or not the exemption was proper.
Correct. Well, I think once the district court made that determination, that we ask that the court find that, as with any summary judgment, the court is a de novo review. So the court makes an independent judgment.
So you're asking us to overturn Hinson and move from clear error to de novo.
Or at least clarify that that may not be always applicable when there are cross motion for summary judgment, and when the requester, like we did here, filed a motion saying you don't have proof to show that you have properly used an exemption because of the time they haven't done anything. And then it is the burden of proof on the defendant, who has the burden at trial of persuasion and proof, to come with the material evidence. And so under the clear judgment, a requester like us will lose that de novo review. If the court is to review and says you came in and you show that there is that you overcome the presumption, there is a genuine issue of material fact, then that's the end of the record. But here, we filed a motion, they filed their own motion. The court did not apply Celotex to our motion and found that they have met the requirement to obtain a judgment. So what we ask is not to overrule Hinson, but to perhaps explain that that may not always be faithful to Celotex in circumstances where the requester is coming up and saying, we're making a showing that you do not have enough to meet your burden, when the defendant has the burden of proof. And I apologize, I'm out of time.
Thank you, Ms. Glazer.
Good morning, Your Honors.
Good morning.
May it please the Court, Alexander DeBobby Norrie for United States Immigration and Customs Enforcement. I just want to start with the colloquy you all had with my colleague about the determination. So the D.C. Circuit has held that a determination comprises 3 different parts. It is the gathering and review of the documents, it is communication about the scope of the documents that have been found and the withholdings that the agency seeks to assert, and then 3, information about the appeal rights. Here, ICE has clearly done the first 2 steps. It has gathered and reviewed documents. Plaintiff no longer has any objection to the adequacy of the search, and the district court has held that the search was adequate. The agency has also communicated the full scope of the documents that it found and has provided information about the exemptions that it is asserting. So at this point, there really is no other determination as a practical matter that the agency could provide. And as the D.C. Circuit explained in Crew, the reason for that determination is to provide either the agency through its administrative review process or the court with reasons to review. And here, clearly, this court has had the reasons that the agency is asserting the exemption. On the matter of the declaratory judgment, this court has squarely held in Walsh, in a very similar case as this one, that once an agency has produced the requested records, that is all the FOIA requester is entitled to. In that case, there were 2 tranches of documents, and the plaintiff received 1 tranche, understood there to be remaining documents, received those after I think it was a year delay, and then came and asked this court for a declaratory judgment about that delay. And the court said that the case was moot. And here, the same thing holds. There's no relief that the court can provide that wouldn't be anything but advisory. Declaratory judgments are not sort of roving licenses to declare wrongs in the past. Their primary impact is to change the behavior of the defendant in the future. And here, there's nothing that can be done to erase the delay that has already occurred.
Counsel, could I ask you, this was something that occurred to me during your your opposing counsel's presentation, but if the government blows the statutory deadlines, as apparently happened here, and then produces the document during litigation, rendering the case moot, would the government then, do you think, be in a position to seek costs as a prevailing party because the case is now moot?
I'm not sure whether the government could seek costs and how.
That would be very troubling to me.
Yeah, I understand that concern. I'm not sure that hasn't occurred. That argument sort of wasn't raised in the appellant's brief about sort of the implication of these matters on costs, and so I don't have any more information on that. What I can say is that the D.C. Circuit has made clear what the purpose of the 20-day deadline is, and the penalty to the agency really is its inability to stop judicial review. Once the 20 days or potentially 30 days, if the agency invokes unusual circumstances, has elapsed, that obviously provides the plaintiff the ability and the recourse to go to district court. And at that point, you have a pragmatic process where the district court supervises production deadlines, can can compel the release of documents improperly withheld. That is the purpose of that deadline in the statutory regime.
Could I also ask you, as I understand it, we're down to one 6-page document.
Correct.
And 5 of those pages have been disclosed, is that right? Or
a large majority of the pages have been disclosed. The district court ordered the disclosure of, I believe it was all the sort of segregable personal information that plaintiff already had. So it's about 5 of the pages, yes.
So it's really about the 6th page.
Essentially, yes. There's like a small point on one, yeah.
And what can you tell us about why that's all still so sensitive that it cannot be disclosed?
Sure. So on the Exemption 7A issue, as Judge Pryor mentioned, really the agency provides sort of 3 categories of justification for its additional withholdings. The first is the Vaughn Index, which categorizes this document as a Homeland Security Investigations report, and as this court and the Supreme Court have held, the agencies can show generalized showing of harm over categories of documents if those categories of documents generally would interfere with contemplated enforcement proceedings. Here, a Homeland Security document is obviously the type of document that is generated
I understand categorically and in
Sure.
general. I was looking at this document and wondering what's so sensitive about this.
So as the agency attested, there is an open investigation currently, and this document is related to that investigation. And as the declaration sort of notes, this document could provide information about how that investigation came about. It also could disclose information on techniques and practices, which I know is a 7E concern typically, but just as a matter of interference with the ongoing investigation and potential enforcement proceedings could also be relevant. And it could, aid subjects of the investigation in evading or circumventing law enforcement. So those are the reasons that...
I understand all that in theory. I'm not asking you to disclose anything that would render the whole issue moot.
Sure.
But I'm still struggling to try to understand what in this page is so sensitive.
Yeah, it's difficult to discuss in open court without more, and I think this is sort of the difficulty that the agencies typically face in 7A issues is you can't necessarily put the level of detail on the public record that is necessary. I think here the agency is relying on the inference the district court made viewing, and now you can make viewing the document in camera about how this document could reveal the scope of the investigation, targets of the investigation, et cetera. Now, of course, if you remain unsatisfied with that showing, then I think that the typical remedy, the appropriate remedy here, would be to remand to the district court with the instructions to ask the agency to go back and provide further information on the record. And the agency could also do so ex parte if needed to provide more explanation on the particular open investigation. I also just want to mention just a couple other points. Plaintiff on appeal raises for the first time the foreseeable harm standard. I think that issue is forfeited. It wasn't raised before the district court. The district court didn't address it. and it was really raised in a perfunctory matter on appeal in only a couple of sentences. So I don't think the court has to reach that issue and how the foreseeable harm standard interacts with Exemption 7A. I would also say that, plaintiff...
There's a request for declaratory judgment, though, that Mr. Lerolf receives from the court saying, yes, ICE violated FOIA.
I think that that would plainly be an advisory opinion. I don't think that that would provide any kind of remedy here. The remedy, as this court made clear in Walsh, is an order compelling documents. That is what plaintiff at bottom seeks here. If you read the complaint, if you read how the summary judgment motions were litigated, and even on appeal, this is really a case about one document, one 6-page document of which there are some remaining exemptions. So that is the, in practice, remedy that plaintiff seeks here. As to the sort of allegations of pattern or practice, similarly here, plaintiff wouldn't have standing to bring that type of a claim, which I think would be improper under the APA. But even if brought under FOIA's pattern or as a FOIA pattern or practice claim, plaintiff provides no information in the record that there are any other pending FOIA requests, that they've ever submitted a previous FOIA request and received a delay like this, or that there are any future planned requests. Again, this is really a case that boils down to one remaining document with some redactions, and that's the issue before the court. If there are no other questions, then thank you so much.
Thank you. All right. That's all the time that we have. Ms. Glazer, I'll go ahead and give you 1 minute for rebuttal.
I will use my 1 minute to read from the interim response because I didn't have it, and that's what the government put in response. Be advised that once all pending matters are resolved and FOIA exemption 7A is no longer applicable, there may be other exemption which would be protected certain information from disclosure, such as FOIA exemption 6, 7C, 7D, 7E, and 7F. This is what they put in the interim response, and they obtained judgment in their favor on this response, basically saying once the investigation is closed, we may be able to do something else to complete your request, but we're not going to do it now. And now that we have a judgment against you, there is no reason for us to do it. And that goes to the core of this case, and that is, if there is permission for them to do so, then the act, stripped from the requirement for final determination, will be completely illusory. Thank you.
Thank you. We'll take the case under advisement, and thank you both counsel for the presentations this morning. We have United States versus Larry Doss.
Thank you. Good morning. May it please the court. Attorney Michael Roy on behalf of appellant Larry Doss. The question in this case is pretty simple. Does touching a buttocks over the clothes without consent count as a crime of violence? And as explained in our reply, my colleague and I actually agree on a lot of the issues and how the analysis should go. Our dispute is solely whether the guidelines definition of forcible sex offense incorporates the definition of sexual act from section 2246(2). Our argument is that it plainly does. And for a couple reasons, but I think that the headline argument is that our interpretation avoids the absurd results of the government's interpretation. Under the government's construction of the definition, it would assume that the Sentencing Commission intended to create an entire category of offenses that are only violent if the offender chooses not to target a child.
And we're under plain error.
That's correct. Okay. Yes, this is under plain error, and I'm happy to answer any questions about plain error. I will skip ahead a little bit. The main reason I think this is plain is there is no case cited by other parties that specifically discusses this issue. It is a blank slate. All the government's cases involve a prior definition from 2008. A couple cases are older than that. None of them construe a definition of forcible sex offense that includes the current sentence at the end of the definition now, which describes which cites an illustrative example. The previous versions of the definition only said, it can be forcible sex offense or statutory rapes like child sexual abuse. They didn't include any sort of citation to other offenses to provide elements or examples of what would be involved in determining whether a sexual act applies.
As you know, Mr. Roy, the government is wanting to somewhat cabin 2241C, 2246-2 to only dealing with minors.
Right.
And so when we're looking at this sentence structure, just for being able to interpret that sentence, how are we able to, or how are you reading it? I want to make sure that I appreciate how that's reading to include consent to the conduct is not given, to the first part of that sentence.
Sure. And there's two textual canons we're relying on. One is the absurd results canon, and I think this court's opinion in Williams is a good example in that if Illinois' aggravated sexual abuse statute had just struck the requirement of age of the victim, it would qualify as a crime of violence under the government's definition, but because it included a minor victim, it does not. The other canon would be the negative implication canon, and that its citation is an illustrative example of what type of thing the court should look at when determining whether it's a forcible sex offense. That is how courts have always construed forcible sex offense. Cases the government cites, Contreras, Romero, Hernandez, those are old versions of the definition, but in those cases the court says, we can look at statutory rape as an illustrative example. That lets us know what type of thing the commission was talking about when they said forcible sex offense. The other...
what do we do, though, with the Sentencing Commission's, in 2008 and again in 2016, we're wanting to broaden this language in their commentary.
True. I mean, there's no doubt that in the 2008 amendment, the commission explicitly wanted to, maybe abrogate's the wrong word for the commission, but abrogate some of the circuit cases that were saying things like rape by coercion or blackmail couldn't be a forcible sex offense. But I don't read that as saying that every single offense without consent is a forcible sex offense. And I think one big clue of that is the 2008 version still felt the need to cite statutory rape, child sex abuse against a minor. If the commission had thought that the language they added about consent automatically encompassed every sex offense without consent, it would have had no reason to explicitly add statutory rape separately. That suggests that the commission still thought that there were additional sex offenses that weren't automatically included by the language they added in 2008, which is the same language that they have now.
Troy, let me just raise a more general concern here about plain error review here.
Sure.
And that is, as you know, the categorical method can get pretty far away from reality and the purposes of sentencing. And if this issue had been raised with the district judge, she would have been able to tell us whether she even cared what the answer to this question was. It would be perfectly rational for a district judge to say, I don't care, I've got reliable evidence about what Mr. Doss did in this prior conviction, and it's bad enough that I think it's appropriate to apply the aggravation circumstance here. Why do you think we should assume, which you seem to argue we must on plain error review, that it would have made a difference to the district judge when she never had the chance to tell us?
I have a couple answers to that question, Judge Hamilton. First of all, the government has conceded prongs 3 and 4 of plain error, and your question seems to go towards prong 3, whether it would have affected his substantial rights. In addition, the same could be said about...
Sorry, how did the government concede that? I wasn't focused on that in the briefing.
Let me find the exact page site. It's on, I believe, footnote 2 on page 5 of the government's brief. The government agrees that if the error is plain, prongs 3 and 4 are also satisfied. And maybe the government can clarify more when they're up, but that was my reading of it. In addition, the same could be said about literally any guideline error. Any guideline error, if brought up before the district judge, would give the district judge an opportunity to say it's harmless, right?
Exactly.
However, in most guideline cases, As long as there's an error and it's plain, prongs 3 and 4 just fall into place after the Supreme Court's decisions in Molina-Martinez and Rosales-Morales.
And my other question about plain error review here is if you say we're writing on a blank slate, how is it plain?
Well, this court has found plain error in the past on a blank slate. Hyatt is a good example. Also, I think as much consternation as the categorical approach causes and as much technical complexity as it brings to cases,
Your chart was
yes,
impressive.
I had been sitting on the chart for a while. I was very excited to finally have a chance to include it.
We're glad you used it. We liked it.
Unfortunately, it didn't matter much because the government agreed with almost everything we said about the chart.
You still included the chart.
Thank you. But I think the whole point I wanted to make with the chart is that technically complex, yes, but it's like a calculus problem. In a sense, categorical approach errors are especially amenable to plain error because you are literally following a flowchart. It's maybe doesn't reflect reality. Like we're not even talking about what Doss actually did in his underlying case, but it does show that there's a set of steps, and then in most cases, it should result in an indisputable answer without any debate between the parties.
So I'm still struggling with the textual basis in this definition of forcible sex offense for extending the 2241 C and 2246 definitions into the broad first sentence.
Sure. I mean, so like I just said, I think it's the negative implication canon. It's the drafting history, the fact that courts had previously been using the examples following the parenthetical about consent as illustrated examples. And then if we assume, like the government does, that the second sentence of the definition does not apply outside of statutory rape and child sex abuse, it leaves us with essentially no definition of what a forcible sex offense is.
So the negative implication canon, what's the second principle that you're leaning on? Of how the how the court has reviewed what in the past? I'm sorry.
Oh, that the other courts in the past have, I guess, followed the negative implication canon to look at those examples as illustrative, and then that ties into the drafting history. And then when we're arguing about absurd results, I want to be clear, I'm not trying to raise that as a policy argument, although I do like the policy implications of my argument there. That is its own separate textual analysis canon.
What's wrong with a definition focusing on that first sentence that just says if you've got a battery carried out with the mens rea of gratifying sexual interests, that's enough?
I think part of the problem is how are we defining battery in that sentence? So presumably it's in a way that's not falling under the elements clause, because if it's traditional battery, something where there's force used, that would automatically be a crime of violence.
I'm not going there. I'm sticking with the enumerated offenses as defined by the commission with that first sentence, since this is not a case of sexual abuse of a minor or statutory rape.
So I guess the reading that you're suggesting based off the government's argument too would be that any sex offense that involves a lack of consent is necessarily forcible. I think the problem with that is literally every sex offense that involves a victim has to have a lack of consent or a lack of valid legally consent. Otherwise, it's just consensual sexual activity. The outliers where there wouldn't be a lack of consent would be things like victimless crimes, maybe indecent exposure. It's not entirely clear to me, though.
The question in front of us is whether sexual battery under the Indiana statute is a forcible sex offense.
Correct.
And so the voyeurism and exposure points don't seem relevant there.
Well, they do, because we still need a definition of what sexual offense means. Even setting aside the word forcible, is it just having a mens rea that makes it a sexual offense, or is it a specific action? Like states vary wildly in how they define even classic sexual offenses like rape or sexual assault. They vary wildly in how they define sexual penetration. Illinois, depending on how it's charged, might define sexual penetration as not requiring penetration, or it might define it as requiring literal penetration. There is an entire universe of ways that these sex offenses are defined. So there's two problems with just assuming, as the government does, that anything without consent is a forcible sex offense. First, we don't know what sex offense means. The government's examples of sexual intent or sexual act just provide different undefined terms that, again, we don't know what they mean. Different states define them differently. And then it's not clear how we're going to differentiate.
Go back, battery for sexual gratification, right? What's wrong with that? As sufficient. I'm not saying it's a complete definition, but sufficient to decide this case.
I would say it's not sufficient to decide this case because we're still not clear on what type of sexual act qualifies as a sexual offense in the first place. I think a good example would be, say, a state defined sexual battery to be, like traditional battery can be any touch that's offensive. It doesn't have to be forceful even. If it's a touch that is offensive and you prove that they had the mens rea of sexual intent, maybe you offensively touch someone on the head or on the shoulder, but you have a mental purpose of sexual gratification. I'm honestly not sure why that would be a forcible sex offense. The issue is what type of touching, what type of battery qualifies as a sexual act or not. Right? Not like if it's just battery and that somebody, I guess someone batters a romantic rival. It's a bar fight. Someone attacks someone because they're hitting on their partner. That is battery with a sexual intent in a sense. But is it a sexual act?
How does that satisfy the Indiana statute with intent to arouse or satisfy a person's own sexual desires or those of another person? I don't see it. But, okay, thank you.
Okay, thank you.
Thank you. Mr. Sitkin?
May it please the court. Good morning, Your Honors. Eli Temkin for the United States. The district court did not plainly err in counting Mr. Doss's Indiana sexual battery conviction as a forcible sex offense and a crime of violence under the federal sentencing guidelines. His offense qualifies under the plain text of the guideline. No court has adopted his argument, and the plain text reading is not absurd. It's useful to talk about this in two steps. First is, just as a baseline, whether his Indiana sexual battery offense would qualify as a forcible sex offense just under the, under the plain language of what a forcible sex offense means. Second is his argument that the second sentence of the forcible sex offense definition changes that. As an initial point, everyone here agrees that Mr. Doss forfeited this argument, so this court's review is limited to plain error, and the district court was not derelict in failing to catch this. The Indiana statute at issue defines sexual battery as if the perpetrator with the intent to arouse or satisfy a sexual desire touches another person's genitals, pubic area, buttocks, or female breast while the victim is unaware. So, on the first question of whether just on its face this is a forcible sex offense, it is. This is in the heartland of what qualifies as a forcible sex offense, as Judge Hamilton pointed out. First, it's forcible. The guideline defines what that means, that it includes offenses where there's a lack of valid consent, as with this one. Then whether it's a sex offense, the guideline doesn't explicitly define that, but numerous federal courts of appeals have construed that language, and they construe it broadly. They say that's what the Sentencing Commission directed courts to do. It's just the kind of interpretive tasks that this court and other courts go through all the time.
So the representation that I'm hearing from the government is that forcible does not always mean physical.
Forcible means through lack of consent or lack of valid consent as defined.
Just pulling Mr. Roy's thread a little bit, the representation is that really then if that's notion, lacking consent, what sex offense would not count as forcible?
There's some on the margins that you could think of. Incest, for example, states that still have adultery offenses, indecent exposure, prostitution potentially, and there are cases that talk about these. That could be those could have some like those could present some tough questions if you're trying to define the outer boundaries of what qualifies as a sex offense. Here, this is sexual battery, and courts consistently hold that sexual battery is a forcible sex offense. Excuse me. And with the hypothetically more challenging offenses, there's also the requirement to qualify under the federal guideline that it be a felony. So not all of those state offenses would qualify. The cases that we've cited in our brief are construing the language forcible sex offense. That was the same language under previous versions of 4B1.2 and where most of those cases come up under 2L1.2. That language is the same, and so those cases are still instructive in saying what forcible sex offense means, and the definitions the courts come up with, looking to dictionaries, looking to the plain, ordinary, and contemporary meaning, are still useful.
In your view, Mr. Temkin, why is the defense wrong in saying this would produce an absurd result, treating crimes against children as less serious than crimes against adults?
Yes, Your Honor. It does not treat offenses that happen to have a child victim just based on the circumstances less seriously.
Age is not an element in this particular charge.
Excuse me?
Age is not an element of Mr. Doss's prior charge.
Correct.
Okay.
What the guideline definition does is it takes an expansive view of what could qualify as a forcible sex offense. And for these two specific offenses, it expands it, but with a limitation. And that's how everyone feels about it as a policy matter. That's a sensible, you could understand why the commission would do that. Statutory rape and sexual abuse of a minor are extremely broad offenses that are strict liability offenses where the lack of consent is established purely by the victim's age. And there are states that have extremely broad statutory rape offenses. For example, in the Esquivel case, the Supreme Court decided, I believe in 2017, it talks about a California law that does criminalize a sexual relationship between a 21-year-old and someone who's almost 17. The Sentencing Commission said that's not a forcible sex offense. This is operating under the categorical approach, and so there are going to be anomalies, but this is about the elements of the offense of conviction. And so in that sense, charging decisions matter. If there's an offense that happens to be against a child victim, but also take Mr. Doss's sexual battery here, where he raped a woman. If he had raped a child, that's still rape. That's not just statutory rape. And so that would qualify as a forcible sex offense, even though, if charged that way and convicted that way, even though the victim is a minor. Beyond that, the text of the guideline is clear that it is imposing this 2241C requirement only for the two offenses of statutory rape and sexual abuse of a minor. If the Sentencing Commission had wanted to extend that to all forcible sex offenses, this was an awfully strange way to do it by saying that it applies only for these two offenses. Sure, there could be some hard cases on the margins, things like voyeurism, public indecency, but the definition, but those hard cases don't require going to this most restrictive definition. If the court feels the need to come up with some more definite approach, there are ways to do that, as any number of other courts have done. For example, the Fourth Circuit in the Alfaro case. Even if the court wants to set out a more precise definition, or even a more restrictive definition, It doesn't need to do that by immediately jumping to this more restrictive version of a sexual act under federal law. The guideline just doesn't instruct courts to do that. To that point, to the point about the argument of absurd results, the government is not saying that child victims are, that an offense against a child victim is treated more leniently. We make that clear on page 23 of our brief. If Mr. Doss's victim here had been a child, the outcome would be the exact same, and this would be a forcible sex offense. Finally, the Sentencing Commission added the current definition in the second sentence to 4B1.2 in 2016. That's the operative definition, and that's different from the 2008 definition for 2L1.2. When the Sentencing Commission added this definition, it again imposed this 2241C requirement only for statutory rape and sexual abuse of a minor. The Sentencing Commission did that against the backdrop of all these 2.1.2 cases construing the phrase forcible sex offense broadly to include any sexual offense against a person. The Sentencing Commission just did not impose this limitation. Regardless, this case, this Indiana sexual battery offense, is in the heartland of what the Sentencing Commission deemed to be a forcible sex offense. For those reasons, the government asks this court to affirm.
Thank you, counsel.
Thank you.
All right, we did speak into your rebuttal, Mr. Roy. We'll give you 2 minutes. We were still asking questions. Go right ahead.
There's just a couple of points I want to address briefly. The first is the government cites sort of sex offenses at the margins that it says would count as sex offenses but not forcible, like incest or adultery. Those are very similar to the sodomy laws that were struck down in Lawrence. We did not do a survey of the state of law nationwide or the debate, but a logical extension of Lawrence would be that some states would have been striking down their adultery laws. I don't know what the status is now, but I don't think that is a good example of why we can say there would be sex offenses that don't rely on a lack of consent but still have a victim. The other thing I want to say is that if this case comes down to standard of review, and I recognize that plain error is a steep hurdle, I would ask this court to not skip prong 1 in the plain error analysis for 2 reasons. First, it helps the development of law in the circuit if the court first determines whether there was an error before determining whether that error was plain. But also, for Mr. Doss personally, conducting the prong 1 analysis does help sort of clarify the question of plainness. It's easy to look at a stack of briefs and say, well, there's a lot of debate on the issue. If there's so much debate, it can't be plain. But actually going through and doing the analysis, determining whether an error happened in the first place, helps demonstrate where the actual evidence, where the case law, where the authority points, and that can help the court determine whether the question is plain or not. Unless the panel has any specific questions, I will see the rest of my time.
Thank you.
All right, thank you.
Thank you, counsel. Case will be taken under advisement. We move now to case number 5, Hammond Power Solutions Incorporated versus National Union Fire Insurance. And Illinois National Insurance Company. Counsel, you may proceed.
Good morning and greetings from Milwaukee. James Goldschmidt on behalf of Appellant Hammond Power Solutions. May it please the court. Resolving this appeal requires some thought about what the parties meant by the term radiation as used in the radioactive matter exclusion. And linguistically, by definition, that term radiation demands a source. Radiation from what? The most reasonable reading is that it refers to radiation from radioactive matter, as used here.
And so what do we do with the or? in the radioactive, in the exclusion.
Yes, Your Honor. So our reading is actually the only one of the two being offered to you that gives independent meaning to both of those provisions. There's the radioactive matter piece, which is contact with radioactive matter, and then there's any form of radiation, which is the radiation emitted from that radioactive matter. It's important to remember that the word radiation, like the word emission, is just an empty sack to be filled with some context, some content from the surrounding context. Here that context is radioactive matter. Without that context, without some tether to the surrounding language, we immediately find ourselves in a situation where
Are there different forms of radiation?
Yes, there are different forms of radiation from radioactive matter, Your Honor. We point that out in our reply brief. So in that sense, our interpretation also holds. This is on page 10 of our reply brief. Those forms include alpha particles, beta particles, gamma rays, X-rays. All of those are various forms of radiation from radioactive matter. And so in that sense, our interpretation does give independent meaning to both prongs of this exclusion. The insurers promise an independent meaning for both prongs, but they never make clear what it is. And it's hard to understand why, if radiation is really so broad as the insurers say it is, that we would need to refer separately to radioactive matter at all. And a reasonable insured in Hammond's position.
So I want to make sure I'm following, is that if we read it the way the insurers want us to read it, it would be superfluous language, basically, to have radioactive matter and any form of radiation.
That's correct, Your Honor. If radiation is so broad,
go ahead.
If radiation is so broad to encompass not just radiation from radioactive matter, but also in their telling sunlight and moonbeams and lightning strikes and all other natural forms of radiation, then we wouldn't need to separately call out radioactive matter as this exclusion does.
At the end of your brief, you suggest, if I understood you correctly, that the phrase any form of radiation would be different from the phrase any and all forms of radiation.
Could you point me to your reference there, Your
Your
Honor?
concluding paragraph.
And is this in our initial brief?
Yes.
Yes.
Okay.
Page 28.
I'll get there.
First sentence. And I'm trying to understand why those two phrases should be interpreted differently.
Yeah, I think that phrase in the conclusion is probably more rhetorical than technical. The point that we're trying to make here is that radiation as used in the radioactive matter exclusion should be understood to refer to radiation from radioactive matter, and that any form of that refers to alpha, beta, gamma, X-rays.
Did any insurance broker tell your client that this policy would cover claims based on electromagnetic fields?
I would say yes, because if we walk through the policy, starting with the declarations page, this is at page 88 of our appendix. Our client, Hammond Power Solutions, is classified as an electric power distribution or transmission equipment manufacturer. And that designation is not just a
Are
throwaway.
you referring to the appellant's appendix, you said?
Yes,
84?
appellant's appendix, page 88.
And just the nature of the business, I understand
Right.
that, but I'm asking for something more explicit.
Yes,
So there was any,
I'm building up to it, if
Okay.
you permit me, Your Honor. What I'd like to point out just about this is it's not just a throwaway designation of the business. This correlates with a 5-digit code that becomes the basis of the premium that is charged to my client for the insurance, which means the carrier knows very well what business my client is in and what they make. And that's the basis for the money they're being charged. So then we get to the granting provisions of the policy, starting with the grant of coverage at page 19 of our appendix, offering to pay sums for bodily injury based on occurrences throughout the coverage territory, which is worldwide. And then when we get to the definition of bodily injury on page 31 of our policy, page 31 of our appendix, it's defined as bodily injury, sickness, or disease sustained by a person, including death resulting from any of these at any time. And then we have to tie that into occurrence, because occurrence is doing some clear signaling here. The definition of occurrence is on page 33 of the appendix, and it means an
You've clearly
accident.
got coverage but for the exclusion.
Well, but Your Honor, that's the case with every exclusion. What we're trying to do here is there something that my client would specifically take away from the policy to conclude that they have coverage
I'll
for
take
their
it.
product?
I'll take it from the answer to my original question is no, but let me see if I understand the extent to which your client's business makes a difference here. Suppose the couple who brought the underlying claim here also named the owner of an apartment building where they lived, where the transformer was installed, and that owner had an identical policy. Would there be any difference in the way the exclusion should apply to the claim against your client versus the apartment owner, who is not in the business of manufacturing electrical equipment?
It would not differ because again, that term radiation as used in the exclusion should not be interpreted to include EMF, period.
It doesn't
However,
depend on your client's business then?
not in that respect, but it does matter, and the reason we highlight my client's business and what the insurers knew they were producing is because of the Wendalco case. And the Wendalco case talks specifically about what I would call the concept, also familiar in Wisconsin insurance law, of contextual ambiguity, both giving and then taking away coverage in a way that itself creates an ambiguity, an interpretation of the policy. And we're not just talking about the kind of giving and taking away every time there's an exclusion. We're talking about a more particular type of giving and taking away. And that's why I'm focused on things like the definition of occurrence, which here specifically refer to continuous or repeated exposure to substantially the same general harmful conditions.
Seeing that we're under Wisconsin law, when you're looking at that exclusion, a reasonable person in the position of Hammond would have thought what?
They would have thought, we make transformers. Electromagnetic fields are inherent in our business in our product, not just our business, in the same way that they are inherent in anything that has electricity running through a wire. This microphone is emitting an electromagnetic field. Judge Ripple's laptop is emitting an electromagnetic field. They would not have looked at a radioactive matter exclusion and thought, that bars coverage for claims related to my product, which is the policy that I'm purchasing for my business in the first place. They would not think that. They would look for an EMF exclusion, and they would look down the list to see if it was there, and they wouldn't find it, and they'd think, great, there's no EMF exclusion. That's not what this radioactive matter exclusion means.
You both cited to the EPA website, and they both say EMT radiation is a common form of radiation.
Yes, that's right, but it's radiation in the scientific sense, in the way that lightning is radiation in the scientific sense. It's not what the layperson thinks of when they hear the word radiation. If you walked up to a man or woman on the street and said, do you think your hairdryer is emitting radiation? They would say, no, it's not radioactive. But technically it is. And when we admit that EMF is a form of radiation, that's because what the science says. But it's not what the typical layperson would understand. And the case on point for that is Crescent Plaza Hotel. This court's decision there says we have to interpret these terms not in their scientific sense, but as the ordinary person would understand them.
Thank you, counsel.
I see that I'm out of time. Thank you for yours.
Ms. Hartman?
May it please the court. Good morning, Your Honors. Kimberly Hartman on behalf of the Appalese National Union Fire Insurance Company of Pittsburgh, PA, and Illinois National Insurance Company. The policies that were issued here contain a clear and precisely worded exclusion, which in a single line of text excludes coverage for bodily injury arising out of exposure to persons to any radioactive matter or any form of radiation. There's no dispute here that the underlying lawsuit against Hammond alleges bodily injury caused by the underlying plaintiff's exposure to EMF radiation. There also is no dispute that EMF radiation is a form of radiation, and therefore, under the plain and clear terms of the unambiguous text, the underlying laws, coverage for the underlying lawsuit is excluded. The exclusion should be interpreted and enforced as written. Neither strict nor narrow construction of an exclusion allows courts to disregard unambiguous policy terms or to create a better contract for Hammond. There's simply nothing in the text of the exclusion or the policy as a whole which indicates that EMF radiation would be excluded from this endorsement. Hammond nevertheless argues that the district court improperly interpreted the policy language according to the literal meaning of the words in the policy and according to Hammond's intent. But under Wisconsin law, the party's intent must be determined by the language of the policy. And the policies here specifically and unambiguously applies the exclusion to any form of radiation.
But what do we do with your colleague, with your opposing counsel's argument that this is our business? Our transformers emit EMT radiation. We would not have signed up for this policy because it goes against the nature of kind of what our business is.
That may be true, but the intent of the parties and the scope of the coverage is determined by the actual written words in the contract. And there are no terms in the contract which would accept EMF radiation out of the definition of any form of radiation. And Hammond, as you look at Hammond as a reasonable and short, Hammond counsel here said that EMF radiation would be something that they would want, that they know that their electronic transformers emit radiation, emit EMF radiation. So there can be no argument that they wouldn't read this provision and understand that EMF radiation is a form of radiation, that their transponders could emit this type of radiation. And reading that Hammond gives, it's unreasonable not only because it deletes the word any, which has broad interpretation. This court, as well as the Wisconsin Supreme Court, has held that when it modifies a word or a phrase, it indicates broad interpretation or broad application. But also, they write out the word or. Or is a disjunctive. The Wisconsin Supreme Court and Hulvey State held that the term or is unambiguous and its meaning plain. Or is a disjunctive connector of alternate choices in a series. Here, there were two risks that are excluded under the exclusion: bodily injury arising out of exposure to radioactive matter and bodily injury arising out of exposure to radiation. And the two are not the same. Radiation can come in a form, can be emitted from radioactive matter, but you can be exposed to radioactive matter in a solid sense, or solid form, or vapor form, and that doesn't amount to radiation. For instance, radium. If you touch radium, you can, repeated exposure to radium, which is a radioactive matter. Radioactive matter is a chemical compound where the nucleus of the atom is unstable. That may never lead to radiation, but you can still be injured by the constant contact and exposure to radium. So what
is it that causes the injury other than the emission of radioactive particles?
Correct. Radioactive matter may never result in a transformation or restabilization, which can ultimately result in radiation. You can be harmed by.
What other language would we use to describe the nuclear particles emitted by the radium nucleus, besides radiation?
That, Your Honor, that would, radioactive matter that is in decay, transforming in decay, that is emitting energy, that is radiation.
Yeah.
But exposure and bodily injury to radioactive matter is not always attenuated with, it's not always in combination with radiation. You, for
I'm
instance.
sorry, there's a reason I went into liberal arts. I want to make sure I have it right. Are we suggesting that radioactive matter and radiation, there's a separation between the two?
Absolutely, Your Honor.
Okay.
Radiation is energy. It's particles of energy that are released in the air. It can come from radioactive matter. It can come from electric or magnetic forces like the electric transponders. It can come from other sources that are naturally occurring. All radiation does not emanate from radioactive matter, and all radioactive matter.
No, it's the other way though. I want to make sure that the argument from the other side is that radioactive matter is radiation.
No, Your Honor.
Okay.
You can be exposed to radium, to cobalt, to plutonium, to uranium, and it's not in a radiating form. Radioactive matter is simply a chemical compound that is has an unstable atom.
We're talking about elements, not compounds.
Correct. Sorry, Your Honor, correct.
Okay. Can we try economics instead?
Sure.
And I always look for evidence and almost never find it in such cases for evidence about what your client would have charged as a premium, what was actually charged in this case, and what it would have charged to issue this policy without the exclusion for radioactive matter and radiation.
Your Honor, I do not have that information, and what I would submit to you is the type of business does not determine the scope of coverage. It's the insuring agreement that and the exclusions which add and subtract coverage.
I know the lawyers only like to look at the language. What I'm suggesting is that these cases would make a lot more sense if we also understood the economics behind them and had that evidence in the record, just as we often, for example, have negotiating history in commercial contract cases.
Sure, Your Honor. And when I don't have a response to that because I don't have information as to how these rates were calculated. But I would say that this is a CGL policy, a $1 million CGL policy, and there's nothing in the rate that would indicate that this policy, despite the plain language, meant to include all risks associated with being an electrical power distribution company as opposed to any other company.
Let's get back into all of our comfort level and talk about words. Your opposing counsel talked to us about the doctrine of contextual ambiguity. Is that doctrine any different in Wisconsin than in most states?
No, Your Honor.
In other words, Wisconsin is basically in the mainstream.
Correct, Your Honor. Yes, you read the insurance policy as a whole, and when you read this exclusion in the whole of the policy, there are no other terms that would restrict or that accept out EMF radiation from the plain definition of any form of radiation. There's nothing in simply the type of business doesn't transform or doesn't provide any additional coverage. There's Wisconsin Supreme Court precedent that the title doesn't control and that if you look at the Falk case, I think that's pretty comparable. And a good example, there was an endorsement, it was titled Farm Chemicals Limited Liability, and it provided liability coverage for injury caused by chemicals, liquids, or gases. And Wilson Mutual argued that it wouldn't apply to liquid manure because it wasn't a farm chemical. And the court said no. The endorsement, despite the endorsement title not mentioning chemicals or not mentioning liquids, the text of the policy did, and it controlled. Now, Hammond notes that that was in a granting provision of insurance, but it doesn't matter because the court found that the plain text there of the actual provision controlled.
In Wisconsin, are our insurance policies, they're subject to are they subject to any kind of state scrutiny, state regulation? Does the form of the policy, does the policy language at any point have to be approved by the state?
Yes, Your Honor, and in fact, this specific endorsement was submitted to the to the Wisconsin Department of Insurance. The title was listed.
Counsel, you got to move back to the mic.
Oh, I'm sorry. When it was submitted and approved by the Wisconsin Department of Insurance, the form's title was listed Radioactive Matter Exclusion, and the description of the form was, this endorsement excludes all liability coverage for any radioactive matter or any form of radiation. And that is found in the appendix, it's document 55-1, page 20.
Would there be any value in our asking the State Department of Insurance to file an amicus brief in this case?
No, Your Honor, I do not think so. I think the Wisconsin law is crystal clear that you read the provisions of the insurance policy, you apply the plain and clear and unambiguous language, and there's no reasonable interpretation of any form of radiation which limits it and accepts out EMF radiation. That you would take out the word any and you would take out the word form. Source is irrelevant under this policy because it says any form of radiation. You would also take out the word or.
I understand. This case was brought in state court, wasn't it? Originally?
It was originally brought in state court and then it was removed.
You removed it, right?
Correct, Your Honor.
Why would an insurance company, which is subject to state regulation, insurance is a state-regulated matter, want to remove, and we're clearly applying state law here, why would you want to remove this to the federal court?
Your Honor,
That would seem to, and get up and talk to us about state law. Why didn't you leave this in state court?
Your Honor, I was not part of that decision-making process. It predates my participation, but certainly the district courts here in Illinois as well as in Wisconsin interpret insurance contracts in the various states and are more than capable of doing so. And in fact, Judge Ludwig in this case correctly applied Wisconsin law. So there was no question that no reasonable insured in Hammond's position would read this.
It does raise, I must admit, I think in the mind of at least one federal judge, a question as to why insurance companies are so scared of bringing cases in the state court, in the state which regulates the text of that insurance policy.
Your Honor,
it does raise a suspicion. Why do you want to forum shop and go to another judge rather than the state court that interprets state law, and you're bound by state law here?
Correct, Your Honor, and I think it is, obviously we insurance carriers respect the state courts as much as they respect the federal courts.
No, I don't think they do. They always remove the cases to the federal court. That's my point.
Right. We can agree to disagree on that, but I guess my
So
point...
maybe we ought to certify this to the Wisconsin Supreme Court and find out what the justices of that court think about this. Why don't we do that?
Your Honor, is there a particular question regarding Wisconsin state law that you think that that I could address that isn't clear?
Well, apparently we're all talking about this contextual ambiguity quite a bit, aren't we?
We are, Your Honor, and I think going back to that, again, I have to reinforce that there was no text in the policy to create an ambiguity here. The exclusion in 8 words sets forth the scope of the risk that's excluded. It's radioactive matter, any radioactive matter, or any form of radiation. And the interpretation by Hammond seeks to either excise out or any form of radiation from the exclusion, because it would already be excluded if radioactive matter resulted in radiation harming someone, or it takes out the or it adds words to the end of the exclusion and changes any form of radiation to mean only forms of radiation that are emitted from radioactive matter. And that violates numerous rules of contract interpretation under Wisconsin law, under Wisconsin precedent.
Thanks.
Thank you.
Counsel, 2 minutes.
Thank you, Your Honor.
Do we know the answer to Judge Ripple's question? Why this case was removed?
I wouldn't want to speculate, Your Honor.
All right.
I think, before I move on, I want to point out on the doctrine of contextual ambiguity, specifically in Wisconsin, we know maybe the Illinois courts haven't received Windelco so well. In Wisconsin, the doctrine is alive and well. The 2 cases I would point you to are Folkman and Maratz. Those are both cited in both of our briefs. The other doctrine that I don't want to lose sight of, in addition to contextual ambiguity, is the Wisconsin line of cases finding that when a particular general term is given its literal meaning, that meaning is so broad as to be absurd and must not be what the parties meant. That's a different line of cases. The primary one on point is Wisconsin Builders. That's also cited in both of our briefs.
That's the H2SO4 rule.
Yes, and
The equation works well, but the result smells bad.
correct. Yes, that's right. And the American States case from Illinois is, of course, applying Illinois law, but explains the rationale of that case, I think, quite well. So that would be another
You
one.
mentioned another case directly before that.
The Wisconsin Builders case.
Thank
Yes.
you very much.
So that
Wisconsin
doctrine also
Builders.
matters. The key point that I'd like to land on and leave you with is our interpretation, Hammond's interpretation here, is at least reasonable. And ultimately, the district judge's decision finds that it is not. That's what we take issue with. If AIG wants to say, give it the broadest possible interpretation, you can entertain that, but you can't conclude that our interpretation is at least not reasonable. And if it is reasonable, we have ambiguity that under the doctrine of contra preferentum requires this case to be resolved in our favor. For that reason, we would ask that you reverse and enter an instruction for the district court to enter summary judgment in my client's favor.
Thank you.
Thank you.
We'll take the case under advisement. Thank you to both counsel. Well, our last case for the morning, Elizabeth Mejia Hernandez versus Pamela Bondi. You may proceed.
Good morning, Your Honors. Budzinski for petitioners. I'm not going to spend much time on the first issue today, but we believe Ortiz-Santiago was wrongly decided, that the defect in the notice to appear is a jurisdictional issue, but I understand the court's been firm in holding otherwise, and I won't belabor the argument. Turning to asylum and withholding of removal, there are 4 issues: whether there is sufficient harm to constitute past persecution, nexus to a protected ground, well-founded fear of future persecution, and internal relocation. Beginning with sufficient harm, the agency concluded there was not sufficient harm here because the harm to family members was not a means to threaten Mejia. However, NLA and Cesar's statements compel a conclusion otherwise. NLA tells us that harm to family members can be harm to the applicant, that is, an announcement, "We are targeting your family." Here, that can be inferred from the harm to various family members. We have 6 murders and 1 injury resulting in someone being in a wheelchair. All of these people are in Mejia's family, and Cesar announced that this was his aim. When he killed Arturo, he yelled, I'm going to finish off all these sons of bitches, all these dogs. I'm going to kill all of them. These pieces of garbage, none of them are going to remain. Contextually, them refers to Mejia's family. Turning to protected ground, the agency concluded that the motive here was not the particular social group, nuclear family, but instead a personal dispute. The record compels a conclusion otherwise because we can have more than one central reason
If
for
we
the
look
harm.
at just the threat of past persecution, and we look at the threat that you just provided for us, what do we have when we're looking just at past persecution before we get to the second element of whether or not it's a nexus? What do we have here that demonstrates or on the record that your Mrs. Mias Hernandez was threatened? Or is this a derivative prosecution claim? I'm sorry, derivative persecution claim.
Based on the harm to her family members?
I'm asking.
Is that what you mean by derivative?
Uh-huh.
Yes, that would be the nexus there, would be based on the harm to her family members. That would be the circumstantial evidence.
No, I want to know what past persecution has the petitioner experienced. That's the first element.
Correct. We are arguing that under NLA, harm to family members can be part of the persecution or harm to the applicant because it announces...
NLA recognizes that that's possible. In NLA, the NLA was directly threatened.
Correct.
And so my question to you is, what evidence do we have of past persecution in this case? We understand that it's possible by threats. And what do we have here?
We have the statement of Cesar when he tells them that he's going to kill all of them. That's the threat here.
So your view is there doesn't have to be direct personal communication between your client and the person admitting the threat, is that right?
Correct.
Can I turn your attention or invite your attention to something that right around the same area, if I may, and that is the question of there having been, there was after each of these murders apparently an investigation, no arrest, but an investigation. We also have the point that your client apparently never told the authorities that she and her family members suggested this Caesar as a. Now, how do we deal with that, with those considerations?
So that goes to whether Honduran authorities are able and willing to protect Mejia. That was an issue not decided below, so we would need to remand to address that.
I see. In other words, the district court never said that the Honduran authorities are able and willing to deal with this.
Yes, Your Honor, the agency in this case, correct.
Could you focus on the question of internal relocation?
Yes.
Mr. Budzinski, since we've got, as I understand it, a record here of at least 8 years or so of safe relocation, and the petitioner's family, at least her nuclear family, remains safe.
Correct, Your Honor. So I do not view this as safe relocation for two reasons, and they're both related to her attempts to relocate. Each time, there was another threat. After the first relocation, they found a note under the door to her home that said, "I already found you, dogs." I think notably there, it uses the same language as the first threat, dogs. After the second relocation, this is when a man matching the description of Cesar's brother was found looking for Mejia with a weapon. Under those circumstances, our argument is that relocation failed and that her last effort was to leave the country entirely and flee to the United States.
Can I ask you a broader question here? And let's go back to Romeo and Juliet, the Montagues and the Capulets. If I understand your theory here correctly, both families would be entitled to asylum in the United States.
Yes, that is true. I think if both of them applied for asylum in the United States, that might be difficult to show future persecution or a change in circumstances, because if they're all here in the United States. There would be no one in Honduras to threaten them. So it's interesting how that would work out. But yes, I think in theory, whoever were here applying for that would have an argument.
Can the other families show there's a present threat of persecution?
I think it would be more difficult for them. I think there was one incident after the dog when one of the family members attacked the Ramirez family with a machete, and he ultimately ended up dying. That person in the Mejia family turned themselves in, and I don't think there's been any violence on behalf of the Mejia family since that incident. So it would probably be a more difficult case for the Ramirez family.
So has she experienced any harm since 2006?
Not since, not personally, except for the man seen looking for her that matched the description of Cesar Ramirez's brother. But other family members did.
And so,
Well,
go ahead,
excuse
Judge
me,
Ripple.
please. No, please.
How does that rise to the level of persecution? The 2018, someone looking for Ms. Hernandez.
So the incidents contributing to a finding of persecution need to be considered aggregately. So we would ask the court to consider the earlier harm, the earlier
You
deaths.
just told me she
along
didn't have
with
any
that.
harm since 2006.
Personally, but we've argued that the harm to her family members can be considered as part of the harm to her because the entire family was threatened, including her.
She's been on the run, hasn't she? Till she
Yes.
got to the United States. I don't know what her situation is now, but she was on the run.
Correct, Your Honor. She
You
relocated
you wanna
twice. Trying
you
to
sure you want to concede she hadn't not been persecuted since 2006?
I mean, thank you, Your Honor. She has been on the run. She has been trying to avoid the harms. She's been threatened those two occasions, once with the note under the door and
Single mother, 2 children, and she's been on the run.
That's correct, Your Honor. Thank you.
And we don't know, but apparently the police have not been terribly helpful in protecting this family.
Yes, Your Honor. If I may, I reserve the remainder of my time for rebuttal.
Thank you.
Thank you, Your Honors, and may it please the Court. My name is Brandon Callahan on behalf of the Attorney General. Your Honors, I think, as we talk about all these various parts of this case, the thing I want to make sure we all remember is how many findings of fact all these aspects represent. The agency made several separately dispositive findings of fact. And so this Court would have to find that, either 2 separately dispositive findings of fact on past persecution or 3 on the concept of well-founded fear of future persecution need to be overturned by substantial, that the record compels the finding that those
I
findings of fact
noticed
be
that
overturned.
language. It's in one of our en bancs. Kind of reminded me of a philosophy professor I said who didn't like one particular writing that we had to look at. And he said to us in French, c'est la poésie et c'est tout. That's poetry and that's all. Is that really a standard that we can apply, that poetic language from our en banc? I mean, that's, there'd be no case that could ever pass it.
Well, respectfully, Your Honor, I think that all of the other circuits use the substantial evidence standard, and it's
They all
formulated.
do substantial evidence, but not the language you quoted from our en banc.
Yes, that the record compelled the finding.
Yeah, isn't that language really in tension with the language that all the other circuits use?
No, Your Honor, I would say no. The Ninth Circuit in particular handles a lot of immigration cases, and they use the record compels the standard as another way of stating
All
the
the
substantial
time?
evidence standard. Yes, Your Honor, and respectfully, the Department of Justice does not always prevail in cases on the substantial evidence standard. So I don't necessarily agree that no case could ever satisfy.
That brings me to my next point. As I went through the case, did my own work I had difficulty seeing what evidence there was that this woman didn't have a substantial fear of persecution if she returned to Honduras.
Well, Your Honor, I think that it's very possible that she has a real substantial fear of future persecution. There's more to the analysis than just whether or not she fears persecution. If we're talking about the concept of past persecution and the presumption that that conveys, then...
Let's give you the benefit of the doubt on that one, okay?
Okay.
And let's talk just about future persecution.
Okay, sure. So if we're talking about future persecution, then she has to show both a subjective fear, which I agree she likely has, and an objectively reasonable probability of future persecution. And to Your Honor's point, there really isn't much evidence in the record that she faces an objective, I think the phrase that this court has used is a reasonable probability of harm in the future. As some
Caesar
of the...
says, I'm going to kill all of your family members.
Yes, Your Honor.
And then in 2011, family member dies, is murdered. 2014, 2 are murdered. 2017, another is murdered. And in 2018, after relocating, someone that fits the description of who she suspects is murdering her family members is now looking for her.
Yes, Your Honor. I take your point well. I think that Judge Hamilton's earlier question to my colleague is appropriate, that it's not clear that Cesar did commit all these murders. There was an investigation. The family never reported their suspicions. Certainly Cesar was not arrested or convicted for any of these things.
Nobody was, right?
I'm not sure about that, Your Honor. I believe you're correct, but the record isn't...
Seemed to be the...
Yes.
Seemed to be the drift of the
yes, Your Honor.
IJ's.
Yes, Your Honor.
Suppose, what I've been trying to do, Mr. Callahan, is separate out these different points of the analysis.
Yes.
And on the persecution point, suppose that Cesar had been a police officer, a government agent, or a member of a tolerated paramilitary organization in Honduras and murdered the grandfather and then the series of cousins and made the explicit threats. Do you think that would be compelling evidence of persecution of the family?
Well, I want to first make sure that I'm keeping all the elements we're talking about straight. Are we talking about whether or not Ms. Mejia Hernandez, in your hypothetical, would have experienced harm rising to the level of persecution? Or are we talking about the question of the nexus between whatever harm she may have experienced?
We've said family membership can be a sufficient nexus, right?
Yes.
And what I'm trying to put aside here is a question that apparently the board did not decide, and that is whether the government of Honduras was unwilling or unable to step in here to protect the family, and just focus on the harm actually experienced by the family as a group, and the threat and the risk of future harm being inflicted. And so assume it's not a purely private vendetta, assume that it's coming from the government. I would think we would say that's pretty strong evidence of past persecution and a very solid foundation for fear of future harm.
Yes, Your Honor. If we took the harm that happened to the family as sufficient harm to rise to the level of persecution.
I would, and it wouldn't? I'm trying to think of a case in which we would say it did not.
Well, Your Honor, I think respectfully in this situation, this case is pretty distinguishable from something like NLA, where the petitioner was targeted to communicate a threat. Or I'm sorry, excuse me, let me rephrase that. The petitioner was targeted, and the way that the persecutors communicated their threat was through targeting other family members. It was part of the threat to the petitioner. That's not what we have here.
I don't know how else you would read this.
Well, Your Honor, nothing in nothing in what Cesar said or has done was meant to specifically target Ms. Mejia Hernandez.
No, it's everybody.
Correct, Your Honor.
I'm not. Go back to the origins of asylum. We're not picking on individual Jews because of their individuality. We're picking on them because they're all Jews.
Correct, Your Honor. But I think that the distinction here between this case and NLA is that in NLA, the family members were targeted as a means of targeting the particular individual petitioner, and that's not what we have here. This is a different case. To go back to Judge Pryor's earlier question, this is also not, I think, consistent with this court's case law about derivative persecution, because derivative persecution, as I understand the court's decision, is more the claim that you experience harm because your loved one was harmed. I think the example that the court uses is if your child is killed.
Mila case.
Gamini versus Holder, Your Honor. I believe that's the language that the court uses. And that is different than what we have here as well, because she's not claiming that she has experienced real harm because her family members were killed. She's using the fact that her family members were killed as corroboration for the threat she faces.
Is that unreasonable?
No, Your Honor, it's not. But I think when we talk about the question of whether or not she's experienced harm rising to the level of persecution, we wind up back at Judge Pryor's question to my colleague, what harm has she experienced? And respectfully, I struggle to find some. She's not actually experienced any physical harm. She's never been directly threatened. She's never even been with any of the people who were harmed. So all we have is a statement she was told about and the fact that other family members have died, she believes, at Cesar's hand. But again, this is not like NLA where those people are being targeted to communicate a threat to her. As part of the threat to her, I think, is the language the court used in NLA. This is different. There is just a personal dispute going on that has continued on for the last 20 years. And if I could get back to Your Honor's question about the objective likelihood that she'll be tortured, I would point out that it's been nearly 20 years since Cesar killed Ms. Mejia Hernandez's grandfather. She lived in Honduras safely for 12 of those years. She also relocated to La Playa for 11 of those years. She's not had any contact with Cesar ever. No one in her family has had any contact with him since at least the last cousin was killed in 2017. Quite frankly, there's not even really any evidence that Cesar is still alive. So there is evidence that she could face a threat, but the question becomes, does the record compel the finding that she faces a reasonable probability of persecution in the future? But as I say, just wrapping up quickly, I think it's important to remember that even if you believe that she experienced harm rising to the level of persecution, or you believe that the harm that she either experienced or fears in the future is on account of her family membership, there are other findings of fact that this court also would have to overturn in order for Ms. Mejia Hernandez to succeed in this case. So if there are no further questions, the Attorney General would ask that the court deny the petition for review.
Thank you.
Thank you.
Mr. Rossini?
Just 2 points, Your Honors. On future persecution, this is not necessarily a demanding showing. The Supreme Court has said maybe even a 1 in 10 chance is enough to establish a well-founded fear of future persecution. And on the last point, respondent was discussing about it being 20 years. Our merits hearing was on December 2019. That's when the record closed. Mejia came to the United States in June 2018. So a lot of this time that respondent is relying on, we cannot rely on unless we remand this case and the record gets reopened and Mejia can discuss what has happened since her hearing in 2019. If there are no further questions.
Thank you. We'll take the case under advisement. Those are all of our cases for this morning. Court is in recess.